Kosovo Specialist Chambers is now in session.
Please be seated.
Good afternoon, everyone, in and outside the courtroom. Madam Court Officer, can you please call the case?
Good afternoon, Your Honor. This is case KSC BC 2020-07, the Specialist Prosecutor versus Gucati and Gucati&Haradinaj.
Thank you, Madam Court Officer. Now I would kindly ask the parties to introduce themselves, starting with the Specialist Prosecutor.
Good afternoon, Your Honor, and to all those here and joining us remotely today. Appearing for the Specialist Prosecutor's Office today are Alex Whiting, Deputy Specialist Prosecutor, Valeria Bolici, Prosecutor, Matt Halling, Associate Prosecutor, Lena Peterson, Case and Evidence Manager, and I am James Potch, Associate Prosecutor.
Thank you, Mr. Prosecutor. Now I turn to the defense, starting with Mr. Rees, please. Mr. Rees, microphone, please.
Your Honor, my name is Mr. Rees. I appear on behalf of Gucati. I'm assisted by co-counsel Mr. Hugh Bowden.
Thank you, Mr. Rees. And Mr. Cadman, please.
Good morning, Your Honor. Toby Cadman for Gucati&Haradinaj, joined today by Legal Associate Miriam Boxberg.
Thank you, Mr. Cadman. And for the record, I'm Nicholas Guillou, pre-trial judge for this case. Before we proceed with our agenda today, I remind the parties that should we experience any technical difficulties with the video conference, please inform the court officer and myself immediately by waving your hand. If the connection with any of the remote participants fails, we will do our best to reconnect immediately. And if the issue cannot be resolved immediately, I may have to adjourn the hearing for a couple of minutes to ensure that the line is reconnected. Let me now move to the recent procedural history of the case. On March 23rd, I scheduled the third status conference for this case. My goal today is to review the status of the case and to organize exchanges between the parties to ensure an expeditious preparation for trial. In particular, I wish to discuss disclosure and the status of defense investigations. I thank the SPO and the defense for their written submissions. There is no need to repeat your submissions in detail, but I will invite the parties to respond to each other's submissions in a concise fashion following each item in the agenda. As usual, I remind the parties to give prior notice should any submission require the disclosure of confidential information so that we can go into private or closed session. Let me now move to the first item in our agenda. I would like to hear from the parties on the progress made in the disclosure of evidentiary material. I remind the parties that several requests related to disclosure are pending. First, the prosecution submission on the materiality of certain information requested by the defense pursuant to Rule 102.3. This is filing F149. Second, the prosecution requests for non-disclosure of certain information requested by the defense pursuant to Rule 102.3. This is filing 154. And finally, the prosecution request for authorization of non-standard redactions. This is filing F155. I note that the defense did not respond to this filing, and I inform the parties that I intend to issue an oral order on this request at the end of the status conference today. In the scheduling order for the status conference, I asked the SPO for submissions in relation to each of the items requested by the defense under Rule 102.3 before the last status conference. I note in that regard that the submission of the Gucati defense, that their request was for such items to be listed in the Rule 1023 notice, and they reserve their right to request access after receiving such notice. In any event, in the scaling order, I asked the SPO to indicate whether the item had been disclosed to the defense, and where that is not the case, the availability and disclosability of such items. I thank the SPO for its submissions on this topic. I would now like to hear the parties on. First, the consideration based on which the initial Rule 1023 notice was put together, keeping in mind that according to Article 21.6 and Rule 1023, the SPO must provide detailed notice of any material and relevant evidence or facts in its possession. Then, on the difference between such considerations and the test of materiality, if any, the inter partes discussions with the defense since the last status conference, the list provided in its annex to its submissions for this status conference. In relation to this list and in view of the additional information disclosed pursuant to the defense requests for several items as provided in Annex 1 of the SPO submissions, whether such items were included in the SPO's initial Rule 1023 notice, and if not, why not? And finally, the impact of the last third-party requests on the disclosure process and the timeline for the SPO's pretrial brief. And finally, and more generally, I would like to know whether the parties are experiencing any difficulties related to the remainder of the disclosure process. A lot of subtopics, I would say, on this disclosure issue. Mr. Prosecutor, you have the floor.
Thank you, Your Honor. I will do my best to address all the issues, but please let me know if I miss any of them.
I will remind you of them, don't worry.
I will start by setting out what the prosecution has previously set out in terms of the approach to Rule 1023, which I understand is the first question which the judge requires clarification on. I refer in particular to our filing from last Friday, the 26th of March, and that is filing 164, it's a reply. And as we set out therein, we note that pursuant to Article 21.6 and Rule 1023, the SPO is obliged to provide detailed notice to the defense of all material and evidence in its possession which could reasonably be considered for or against the accused. We understand this to mean that there is a need for at least an initial assessment, and that is in contrast with certain submissions made by the defense, which in our understanding implies the defense would like any and all material without any initial review to be placed on a list. That is not what we understand the law or the rules or Your Honor's framework decision to mean. That being said, as we set out in our reply, we fully understand that the assessment must be done in good faith, and that the notice obligation is a broad one for 1023 purposes, and that goes beyond items directly relevant to the facts. As we have also previously set out before Your Honor, we understand that the 1023 process is something that happens after a determination in relation to what is going to be disclosed pursuant to Rule 1021B and pursuant to 103. So the prosecution did that. We reviewed all material. We considered what to disclose under Rule 1021B and what to disclose under Rule 103, and reviewed the remaining material in terms of our disclosure purposes for Rule 1023. Now, multiple times in these proceedings, the defense has made an issue of the fact that the Rule 1023 notice was limited in volume. And to that, our response, which we have also put forth before Your Honor, is that we adopted a wide approach to all three categories. However, that meant that the information disclosed under 1021B was voluminous, and the same under 103. That meant that, naturally, the residual material was limited in scope. In terms of the arguments by the defense in relation to listing, as we also have set out in our reply, the Specialist Prosecutor's Office is not obliged to confirm or deny possession or to provide detailed notice of irrelevant items based on nothing more than a bare request from the defense to do so. So this is clearly one aspect in which the prosecution and the defense have different opinions on what should be done. And we, of course, submit that our understanding is the correct one, as it is founded in the law, in the rules, and also in Your Honour's framework decision in particular. In terms of some of the other issues that Your Honour requested submissions on, in terms of the disclosure to the defense subsequent to the requests, when we responded to the requests, we understood it to be disclosure requests as well. The items that we did provide were not on the Rule 1023 notice. We see no need to add it to the 1023 notice when we are providing such items. In particular, in this regard, we have to remember that the SPO has disputed the materiality of 2 of those 27 requests, and as we set out in our submissions on that issue, the reason why we seize Your Honour is because we feel that we have discharged our obligations to the extent that we understood what the defense wanted through those 2 specific requests. Otherwise, we don't know what else it includes because it is overly broad and does not allow us to truly understand what else the defense is after. So when we seize Your Honour in relation to materiality, as we set out in our submissions, it is both because the request is broad and we don't know what it means. Also, we find it unfair for something to be phrased in such broad terms, using terms such as all material. And also because materiality, of course, indicates that we do not feel the defense established even the prima facie reason for that information to be provided, whatever that information, in addition to that disclosed, may be. I'm not sure if Your Honour wanted anything else in particular at this stage in relation to disclosure. If not, I can move to the third-party requests update. So in relation to the third-party requests, in our submissions prior to the last status conference, we noted that there were 2 such requests. Since that time, we received, I believe it was on the 18th of March, a response to one such request, and we disclosed the material emanating therefrom the day after. We are yet to receive information from the second request that we had mentioned. We are doing everything that we can to obtain that information before the 9th of April deadline as set out in the consolidated calendar. Of course, because the request is to a third party, we are somewhat dependent on that third party, but we will of course keep Your Honour informed, and we will make any necessary submissions in terms of whether delays are envisioned or whether there are any other steps which we could take in that regard. So for now, unless Your Honour has any more information requested of me, I thank you for the time.
Just one question before I give the floor to the defense. Some initial material were not disputed in terms of materiality, but they were not in the initial list of the 1023 material. Is there a specific reason for that? Because you've disclosed them at a later stage.
Yes, Your Honour. When we disclose such material to defense, I believe we did provide a caveat that we are not providing the provision of such material is without a concession as to the materiality thereof. In the spirit of what Your Honour ordered, and also in the spirit of cooperation, where the defense requested items which we found could be somewhat reasonable, despite the fact that we did not think that they did fall under our disclosure obligations as such, we provided that material. The prosecution in this case is not trying to hide anything. We are happy to cooperate where that is possible and within the realms of reasonability. I won't get into too many details unless Your Honour wants, in which case we would move to private session. But for example, in relation to 3 of the requests of the defense among those 27 requests, we provided certain publicly available information. The prosecution did not assess that that information is going to be in any way useful to defense because they have nothing to compare it to, pursuant to a request from Your Honour. and I'm sorry to be speaking in very broad terms. If Your Honor does not understand what I mean, please let me know, and we will move to private session. So although we did provide, for example, certain orders and certain requests to the defense, we did so not because we thought that they did fall within our disclosure obligations as such, in particular for the reason that we're not certain what the defense want to do, but we understood the defense to be requesting the provision of that material so that they could have, for example, a confirmation of the existence thereof. Certain information we disclosed to the defense made mention of certain material. We did not think that material needed to be disclosed, but because the defense raised it, we thought, okay, that's fair, we refer to it, then we provided it to them. So that is the reason for that, really. Thank you, Your Honor.
Thank you, Mr. Prosecutor. Now I turn to the defense. Mr. Rees.
Your Honor, the SPO says that it does not understand what has been requested by the defense. What has been requested is perfectly clear, and it is what Your Honor has previously ordered. The framework decision of Your Honor at paragraphs 46 and 48 required the SPO to prepare and disclose a detailed Rule 102.3 notice of all material and evidence in its possession without delay. That is what is being requested from the SPO. The Rule 102.3 notice, Your Honor said, was to comprise any residual information potentially material to the defense after the items have been presented and exculpatory evidence disclosed. Your Honor said, quite properly, that the formulation material to the defense preparation was to be construed broadly and was to refer to all documents and objects of relevance to the preparation of the defense case. Your Honor made the point that what is relevant should not be necessarily limited by the temporal scope of the confirmed indictment, nor should it be confined to material relevant to counter in the SPO's case. Your Honor said in the framework decision that defense preparation is a broad concept, need not be limited to what is directly linked to exonerating or incriminating evidence or related to the SPO's case. It follows that the formulation of Your Honor in the framework decision, residual information potentially material to the defense, is to be construed even more broadly than the formulation material to the defense preparation. Your Honor has already noted that the SPO has been disclosing to the defense items which have not previously been on the Rule 102.3 list. That list, which is required by Your Honor and by Rule 102.3 to be a detailed notice of all material and evidence in its possession and to be disclosed without delay. The SPO clearly do not understand, or at least they do not accept and refuse to accept, Your Honor's clear ruling as to the very broad scope of that list, and of course, the very broad scope of the list as required by Rule 102.3 itself. Your Honor, we have put in submissions as to the scope of Rule 102.3 and the notice required therein, both in writing in relation to the submissions for this status conference, which Your Honor will find at paragraphs 5 through to 15. Your Honor will know that we have also put in detailed submissions, again on the scope of the Rule 102.3 notice, in filing F00157, which is a confidential filing. There are, within that filing, there are further submissions designed to assist the SPO in interpreting the very broad scope of the Rule 102.3 notice. Is Your Honor content for me to refer to those submissions? I can direct Your Honor to the specific paragraph, if that assists.
I don't think it's necessary. I have your submissions.
Well, in which case, I'm not sure I can assist any further. At some point, Your Honour, the SPO has to acknowledge that there is a distinction between the Rule 1023 notice and the very broad scope of that notice, as Your Honour has set out, a notice requiring details of all material and evidence in the possession of the SPO, and the second distinct stage, which is set out within Rule 102.3, which is the handling of requests by the defence to view material from that Rule 1023 notice. The materiality test that the SPO seeks to apply now to the compilation of the notice itself does not apply to the notice. The materiality test that it seeks to apply relates to the second later stage, which is any requests from the defence to see material, inspect it, or have disclosed to it copies of material that is listed on the notice. At some point, the SPO has to acknowledge that distinction and recognise Your Honour's clear ruling and comply with it. Yes, I can assist any further at this stage, Your Honour.
Thank you, Mr. Rees. I might give you the floor a little later, but first, Mr. Cadman, on this specific issue of the Rule 1023 notice first, and especially on the test of materiality and the unicity of the test, or is it a two-stage process, as Mr. Rees just mentioned? You have the floor.
Thank you, Your Honour. First of all, just let me say thank you, Your Honour, for agreeing to move this hearing to the afternoon so that I could attend. I'm grateful for that. The first point I would make is that the defence for Mr. Haradinaj has joined the defence for Mr. Gucati in the written submissions, and actually joins the position put forward today as the joint defence position. These are matters that are not new to the SPO, and they're not new to this court. We have been repeatedly putting them forward for some time. So I don't want to repeat what's in the written submissions and what counsel for Mr. Gucati has already said, as it will just be repetitive. What I will say is that part of what the prosecutor has responded to relates to a request, a detailed request that we had put to the prosecutor following our own defence investigations that demonstrate that very little has been done in terms of a proper investigation, and so that's obviously going to cause some difficulties. We have received a response, and I'm grateful to the prosecutor for responding to those matters that have also resulted in the disclosures that have been made, certainly within the last couple of days. But I think that there is some concern as to the SPO's position that they appear to rule whatever request the defence makes as irrelevant information and does not meet the test of materialities. That is some concern, and so I will just join what Mr. Rees has already said in relation to that. I see Mr. Rees put his hand up, so I will defer to him. But our position is joined in this regard, and we have to continue to express some concern as to the manner in which the SPO is conducting themselves in terms of what they believe their obligations to be, and not following Your Honour's ruling.
Thank you, Mr. Cadman. Let me turn to the prosecution again. If you can elaborate on what Mr. Rees just explained on the materiality test, I would especially like you to give more detail about how do you interpret Rule 102.3 and Article 21.6. Especially, do you see your obligation to provide notice, as Mr. Rees just mentioned, as a two-step process? First, you identify the list, and second, I'll give you the floor in a second, Mr. Rees. First, you identify the list, and then you basically respond to the request of the defense that is using the materiality test at this stage, or do you use one materiality test, whether it's prima facie first and then with the defense request, when you prepare the Rule 102.3 notice? Before I give you the floor, I see that Mr. Rees wanted the floor urgently. So I give you the floor very briefly, Mr. Rees, because I wanted to hear the prosecution on that. Please.
Thank you, Your Honour. It was only to remind Your Honour that it's not my submission that there is a two-stage test, or at least I do adopt that. It is, in fact, Your Honour's already ruling in the framework decision that there is a two-stage approach. Your Honour has ruled at paragraphs 46 to 48 of the framework decision that the SPO are to prepare and disclose a detailed Rule 102.3 notice of all material and evidence in its possession without delay, and Your Honour added by that stage by the 19th of February 2021 at the latest. Your Honour then continued that thereafter the defence shall indicate to the SPO which items among those listed in the detailed notice it seeks to have access to by way of disclosure or inspection. Your Honour has set out that two-stage process. It's one that we agree with, and it forms part of Your Honour's order.
I'm glad you agree with my decision, Mr. Rees, but now I would like to hear from the prosecution if they agree as well. And the other main question is, what is the test for these two steps? Because that is something that is apparently in dispute between all of you. Mr. Prosecutor.
Your Honour, I'll start by saying something we've said before, which is that the case against the accused is simple and straightforward. The SPO fully understands and has satisfied its disclosure obligations and will continue to do so. The relevant information has been in the defense's possession for a while now. The defense has tried to distract from the core issues at the heart of this case, including by seeking information that the law and the rules give them no basis to obtain. Your Honour has previously issued an order to the defense to inform the prosecution of any items they deem should be added to the Rule 102.3 list, setting the 5th of March as a deadline for that. The SPO received one such request and responded to that in detail, as we also reported to Your Honour. And after that deadline, we also received another request and responded to that one as well. What we have heard counsel for Mr. Gucati say today, echoing previous submissions, is that all material and evidence in the possession of the SPO should be on this list. This is not what the SPO is obliged to do, Your Honour. Neither would it be a workable solution. First of all, the SPO, as Your Honour and everybody here well knows, investigates multiple cases. I'm not sure what listing information in relation to other cases would do to advance the proceedings in this particular case. We do understand, as I've said, disclosure obligations. I won't go over what I said earlier, specifically as set out in our reply. Yes, we do understand that there is a two-step test. That's not something that we can contest. The rules and Your Honour told us to list material and then to disclose any requester from. We understand our requests, our obligations to be broad ones, as I already explained. I will say that although Your Honour has ordered the defence to point out any material they believe should be on the list, when we did respond on both occasions to the defence, we heard nothing further. The only pending issue to our knowledge is that before Your Honour in relation to the two requests that we disputed the materiality of. The defence submissions have always been with the caveat that this is not an exhaustive list. And of course, the defence, in our opinion, is using this listing interpreted in an overly broad manner as an excuse to find, I'm not exactly sure what, Your Honour, and that should not be allowed. The proceedings need to remain focused. When the defence has made requests, as I explained earlier, and we have deemed that although they're not within our 102.3 obligations, that's not a problem, we can disclose we did so. I will give another example of that, Your Honour. Actually, it came to me after I provided my response earlier. And that is, for example, the SPO had previously extracted information from certain documents and then disclosed them in another format. The defense took issue with that, or seems to have taken issue with that, and The SPO deemed that although we had disclosed the relevant information in order to appease the defense and in the spirit of cooperation, we will nevertheless disclose the original documents, and we did so. In that case, Your Honor, for example, those items were not on the Rule 1023 list because we had actually disclosed the relevant contents thereof. So all this to say that we have listened to the defense requests in terms of what they believe to be on the notice. We have disclosed that which we believe they could be reasonably entitled to, and we have seized, Your Honor, when we had issues in that regard, as Your Honor instructed us to do. I will also like to address the fact that the Haradinaj, counsel for Mr. Haradinaj, has said that very little has been done in terms of investigations, which echoes that which was included in the Haradinaj submissions for this status conference. In that regard, Your Honor, I and the office, of course, disagrees. These submissions, based on the questions put by the Haradinaj defense, are another indication that the defense is seeking to make this trial about something that it is not actually about. I believe it was something like 12 of the 39 requests we received, which concerned, for example, the identification of the person who dropped the documents at the KLA War Veterans Association. We have disclosed, as we have said before, and we've informed defense before, the information we have about steps taken regarding the potential identity of that person. Particularly, there was one interview which we provided to the defense. I'm not sure what exactly the defense hopes to achieve by, for example, scouring through hours of CCTV footage from all neighboring buildings or the street in order to identify the person who dropped this information off. The accused are not charged with having dropped the information off. The charges specifically relate to what happened right after they received that information. To the extent that the defense is concerned about any SPO involvement in the provision of those items, the SPO has said multiple times, and I will say it again, there was no SPO involvement. There was no entrapment and no sting operation. Beyond that, Your Honor, I'm not certain what we can do. Those are my submissions, unless Your Honor needs anything further in this regard.
If I may, because I'm a little stubborn, on the materiality test, is it the same test you apply when you prepare the 1023 list? And do you think it's the same test that should be applied by the defense? Or do you see this as Mr. Rees presented in its written submissions, as a different one?
The test which the defense seeks to put forward goes far beyond what is required in terms of the Special Prosecutor's Office obligations. We do not contest that there is a two-step process, which is listing and then thereafter disclosure. And we understand that the listing is done pursuant to Rule 1023, which refers, of course, to Article 21.6. And we have interpreted in that regard also in the spirit of the framework decision, understanding them broadly. We put that on that list because, for example, what we may understand as material or relevant to defense preparation, the defense may not have an interest in. So the purpose of that list is for us to put that over there, and then the defense, as they have already done in this case, can request which items they want. They don't need to request every single item. In this case, they have, other than one item, which is a forensic copy of another. So there's no argument about the fact that this is a two-step procedure. It would be pointless of us to argue that it's not, because it is, and Your Honor has so ordered. The difference between the parties is clearly the fact that the defense wants a list, the initial list, to essentially be one with no parameters whatsoever. We have heard it today, and before, again, that it is all material and evidence in the possession of the SPO which should be listed. There is no basis for that assertion, none whatsoever. And as I said, should that have been the case, proceedings would be endless. There would be hundreds of requests for protective measures, disputes as to materiality. That is clearly not what was intended by the framework that we have. So, Your Honor, just again to be clear, and I know I'm repeating myself, we interpreted our obligations broadly. We listed that material. When the defense wanted that material from the list, we provided it. Thank you, Your Honor.
Thank you, Mr. Prosecutor. Mr. Rees, I imagine that you want to reply.
I do thank you, Your Honour, and I think with your Honour's leave, I should be allowed to refer to just the conclusion of my filing F00157, because Mr. Pace has inaccurately suggested that we propose a test for the first stage, the compilation of the Rule 1023 notice, which has no boundaries. Firstly, the SPO has Your Honour's framework decision. And Your Honour's framework decision uses the words that are set out in Rule 1023 to set out the scope of the notice. They're not my words, they are the words that are set out in the rules. And as Your Honour quoted, those rules require the SPO to prepare and disclose a detailed Rule 1023 notice of all material and evidence in the prosecutor's possession. Those are the words of Your Honour and the words of the rules. Your Honour, in the framework decision, set out what that formulation was to include, and it was to include any residual information potentially relevant to the defence. So the materiality test that the SPO applies is a test to be applied to request for disclosure or inspection of items from the list. The list itself, according to Your Honour's framework decision, is to be compiled using a different and broader test, namely information potentially relevant. In our submissions filing F00157, we gave some further assistance to the prosecutor as to what that might mean, what might potentially relevant material mean. And we suggested it should include all material which has some relation to an offence under investigation or any person being investigated or on the surrounding circumstances of the case. That is not a test without boundaries. It's a perfectly explicable test, and it's one in which any investigation ought to easily be able to comply with, because they should be aware themselves of what material they have, which has some relation to any offence that they're investigating, or any person that they're investigating, or on the surrounding circumstances of the case. So I am glad that the prosecution seemed finally to accept that there is a two-stage approach in Rule 1023. The SPO has not said, whilst they acknowledge that there is a two-stage test, they have not set out what test they apply to the production of the first stage, namely what material should go on the Rule 1023 notice. And we say that, in fact, Your Honour has already set out a ruling on the scope of that notice, and we have provided further submissions which we hope clarify and will assist the SPO in complying with Your Honour's ruling going forward.
Thank you, Mr. Rees. Mr. Cadman, do you have anything to add on this topic?
Your Honour, there's not much I can add that Mr. Rees hasn't already stated. We on the defence side agree on what the test should be. Again, we're not seeking material that is related to other ongoing matters. I think it would be rather silly of us to suspect that the SPO is not dealing with any other cases. We're only asking for matters that are potentially relevant to this case. And other than that, there's nothing further that I can add.
Thank you, Mr. Cadman. Mr. Prosecutor, on this, do you have anything to add? No? Oh, just before we finish the topic of disclosure, I ask you what were the result of the inter partes discussion. I understand that some problem have been resolved, so to say, because there's been a couple of documents that have been disclosed in the past week or past weeks. Is there any room for further inter partes discussion, or now is there an urgent need to resolve the matter we just discussed in order to finalize the disclosure process? Mr. Prosecutor.
Yes, Your Honour. So, as I said, we responded to the defence the defense did not subsequently get back to us in relation to any specific parts of our response, should they be willing to, for example, provide more clarification or have further questions arising from either our response inter partes, as also submitted to Your Honour, or from the material we disclose as a result thereof, we'd be very happy to engage. That's obviously not a problem at all. And this applies to both requests from the defense, the first one being from the Gucati defense, which Your Honour has now been informed of through the annex to our submissions for the status conference. And Your Honour has not been informed about the specifics of the other inter partes request, which I referred to earlier. But in that, rather than request, it was posed as questions to the prosecution about our investigation, which we, of course, interpreted to be a question as to whether certain material is or is not in our possession. We responded to the defense, and again, from that, we haven't heard any further communication. We welcome that, Your Honour. That's not a problem. One of the issues that, of course, is one that divides the parties in this case is that we have clearly and many times now said that in creating the list, we're mindful of our obligations under the statute and the rules and the framework decision, in particular paragraph, I believe it's 45 thereof, Your Honour, and that is how we created the list. I'm not sure, maybe something was lost, but to be clear, that is the basis upon which we created and generated that list. Also reminding Your Honour of our submissions earlier about the fact that the large volume of material disclosed under other rules necessarily meant that this list was going to be relatively shorter. So we have no problem, Your Honour, engaging in further requests in this regard. I do note Your Honour has set the 5th of March as the deadline for the request by the defense to add any particular material, but it does not seem that the exchange is being particularly productive in terms of the defense is still requesting, Your Honour, for us to provide a new list. That's not going to really get us much further. If there are further specific items or categories, we would be willing to respond to that again, of course, Your Honour. Thank you.
Thank you, Mr. Prosecutor. Mr. Rees, on these inter partes discussions, you have the floor.
Well, we're grateful, Your Honour, that we have had some further disclosure from the SPO in relation to our requests that have taken place on an inter-parties basis. We do acknowledge that, and we're grateful. We do agree with Your Honour's assessment, though, that at this stage there is an urgent need for Your Honour to really set out, if needs be again for the SPO, a clear approach for them to apply into producing the Rule 1023 notice. We have, as Mr. Pace has said, suggested a number of different items or categories of material that should, we expect, appear on the Rule 1023 notice. And although it has been skirted over very briefly by Mr. Pace, there are two very important categories that have been referred to in their third status conference submissions as category or request A and request B. Two important categories of material that are subject to an application by them to Your Honour, which we've responded to, and yet to be determined. As Mr. Pace has said, when we have put forward suggestions for types or categories of material that we would expect to be on the list, we have always made it clear that that list, our suggestions are not exhaustive, and that's because it is clear on the face of Rule 1023, and it makes perfect sense, that the responsibility for putting together the Rule 1023 notice of all the material in the prosecutor's possession, that responsibility falls upon the specialist prosecutor. They know what they have. They know the full extent of the material and the detail of it in the way that the defense do not, and they cannot abrogate their responsibility in that regard by simply asking us to continue putting forward suggestions to them as to what material should be on the list, and then avoiding using the list and simply applying a materiality test to what we have suggested in a spirit of cooperation with them to assist them in complying with their obligations for the Rule 1023 notice. As we've said previously, and we repeat, we regard that notice as the fundamental building block of the disclosure process, and it can't be bypassed with the SPO just seeking to move everybody onto the second stage in the approach in Rule 1023 and applying a materiality test to any correspondence we have with them. That fundamental building block of a complete and detailed Rule 1023 notice of all the material in their possession has to come, and it has to come urgently so that we can properly commence the disclosure exercise in accordance with the framework decision as Your Honour has directed.
Thank you, Mr. Rees. Mr. Cadman, do you have anything to add on these inter partes discussions, and if this can continue and there is hope on your side that things can improve before I issue the 2 pending decisions on the prosecution's request?
Your Honour, what I would say is that the position as put forward by Mr. Rees has to be the correct one. And what I would say is, yes, things can move forward, but there needs to be a fundamental shift in attitude. Constantly referring to defence requests as a distraction or an irritation doesn't help matters. Actually, smiling and laughing at the reasonable requests that have been made does not help the relationship. Of course, we want to work in such a way where we can have reasonable discussions with the prosecution, but unfortunately, there has to be a fundamental change in attitude in order for that to happen. One other thing that I would seek Your Honour's intervention in, not a matter of responsibility on the SBO, and that's access with our clients. Currently, the difficulty we have in taking instructions on material is that all conferences are divided by a glass partition. I understand why that might be necessary, but as we are moving towards a relatively tight timetable, it is virtually impossible for us to have meaningful discussions with our clients when we are subjected to such meetings. That is going to require the court to intervene with the detention facility, because certainly on my last visit with Mr. Haradinaj, I was not able to share any documents other than putting documents up on a glass partition, which is not an appropriate way to manage these proceedings.
Thank you, Mr. Cadman. Madam Court Officer, I will ask you to convey what Mr. Cadman just mentioned to the registrar and to engage with him to find an appropriate solution for the discussions between the counsel and their clients. And we'll try to resolve that in the following days or weeks, Mr. Cadman. Let me turn to the... Do you have anything to add on disclosure? Yes, Mr. Prosecutor.
Just briefly, Your Honour, just because of the remarks made by counsel for Mr. Haradinaj, should Your Honour wish to see how seriously we have taken the defence request, we have absolutely no problem forwarding you or submitting officially even the responses we provided. I'm not sure where the references to smiling, laughing, or irritation come from. We've addressed them in detail. By way of example, in relation to the Gucati submissions, essentially what we submitted to Your Honour was an updated version of what we submitted to the defence in response, and we took the counsel for Mr. Haradinaj's submissions as seriously. Of course, we disagree on certain principles, but we address them with all caution and all seriousness. These are not light issues to make light of. I will say that unless Your Honour intends to change the parameters of the framework decision in relation to 1023, the SPO does not see the need for any ruling in relation to the SPO's obligations, as we have set out. And I will just highlight, just for the avoidance of any misunderstandings, that the only 2 issues that remain outstanding after this exchange inter partes are the 2 which the prosecution seized the pre-trial judge in relation to, which of course we did according to the procedure set out by the pre-trial judge. And those are my submissions, Your Honour. Thank you.
Thank you, Mr. Prosecutor. I turn to the defense. No, nothing to add on the... Mr. Cadman, please. Mr. Cadman, microphone, please.
Just one final point, that we haven't had an opportunity to respond to the prosecutor just to make it very clear that we do fully intend to respond, and I may be jumping ahead, but on agreed facts. That was part of the problem with not being able to have sufficient contact with the client. We do wish to respond to that in due course, and we will be responding substantively. And it is anticipated that much can be agreed, but of course that requires us being able to have proper contact with our clients.
Thank you, Mr. Cadman. For the next point on the agenda related to defense investigations, I note that despite the COVID-19 restrictions, investigations have commenced, and that at least one defense team has been able to undertake investigations in Kosovo, and that a further trip is also planned by the same defense team. I also note that the registry filed ex parte submissions on support and assistance regarding travel and investigations provided to Defense Counsel. I thank the registrar for her submission. I invite now the defense to provide an update on the status of its investigation and approximately how much time it will need to finalize such investigative activities. Mr. Rees, please.
You know, our position remains as we previously estimated it in the last two status conferences. Your Honour has set out the calendar going forward, and we do expect, despite the ongoing difficulties with travel and indeed the disclosure issues, we do expect that we will be able to meet the targets that Your Honour has set down for defence preparations in that framework calendar. We have previously said that we anticipate being ready for trial from the week commencing the 30th of August onwards, and we fully expect still to be able to do that, Your Honour.
Thank you, Mr. Rees. Mr. Cadman, please.
Your Honour, likewise. We believe that there are some difficulties still in advancing the investigations. I don't want to get into a further disagreement with the SBO as to whether we consider those investigations have been properly conducted or not, but there have been problems due to certain lines of inquiry that we are required to carry out that have not been carried out. And so that is going to extend the defence investigations, but I think we are still well within the timetable that has been set out. And as just stated by Mr. Rees, we are hoping to carry out a further defence investigation within the next week and a half. That's likely to be both defence teams, but of course that depends on the changing situation as far as COVID is concerned. So if the whole of Europe is placed on a red list, it makes it more difficult for us to be able to carry those out. But we will of course notify Your Honour if there are any further interruptions to our ability to carry out the investigations.
Thank you very much, Mr. Cadman. Mr. Prosecutor, do you have anything to add on this topic, and maybe also on your pretrial brief, if there is any change in the expectation that it will be filed by 9 April? You have the floor.
Thank you, Your Honour. Mindful of the consolidated calendar in which Your Honour set out that Your Honour intends to transfer the case to the trial panel on the 30th of June this year, we have nothing further to say in relation to the timeline subsequent to that, or nothing further to add in relation to defence investigations. And in terms of the pretrial brief, yes, Your Honour, we will be filing it by the deadline, which is the 9th of April, along with the other material we are ordered to file by that date. Thank you.
Thank you, Mr. Prosecutor. I would now like to ask the parties about their views for a suitable date for the next status conference to address any outstanding matters before the transmission of the case file. I note that the defense for Mr. Haradinaj expressed a preference for the end of April, and the defense for Mr. Gucati proposed to hold the status conference 14 days after the SPO has provided a new Rule 1023 notice. In light of this, I intend to schedule the next status conference at the end of April. Do the parties have anything to add on this? Mr. Prosecutor?
No, Your Honor, we're available when Your Honor deems necessary. Thank you.
Thank you, Mr. Prosecutor. Mr. Rees, please.
No, other than I'm very grateful that in previous status conferences, whereas Your Honour has set down, if you like, a target for the next status conference, Your Honour has very kindly allowed submissions to be put into the CMU closer to the time for the exact time and date of the hearing. And I'd be very grateful if Your Honour would allow the same opportunity for this for what will be the fourth status conference, bearing in mind that Your Honour said Your Honour would wish there to be the fourth status conference towards the end of April.
Thank you, Mr. Rees. Just on that point, I just need a little of time to myself get acquainted with all your submissions. So it cannot be the 12 hours before, but at least, no. I think 48 hours, the time also for the filing to be distributed seems like a reasonable time, if you're all in agreement. Mr. Cadman, please.
Your Honour, only that I would be unavailable for the 26th and 27th, but I would be available for any of the other days of that week, the last week of April.
Thank you, Mr. Cadman. This is noted. And I think the 27th is actually King's Day in the Netherlands, so I don't think we will plan a status conference on that day. You will receive a scheduling order in due course that will include the agenda before the status conference, and I invite the parties to make any written submissions if they would like to raise any specific issue during the next status conference. At this point, I would like to ask the parties whether they have any other issues they would like to raise. And as usual, I remind the parties to give prior notice should any submission require the disclosure of confidential information. Mr. Prosecutor.
No further issues, Your Honour. Thank you.
Thank you, Mr. Prosecutor. Mr. Rees, please.
No, thank you, Your Honour.
Thank you, Mr. Rees. Mr. Cadman, please.
Nothing from me, Your Honour. Thank you.
Thank you, Mr. Cadman. I will now break and we will resume the hearing in 30 minutes for a short period, during which I will issue a couple of oral orders related to the timeline for the next procedural steps. It is practically 4 o'clock, maybe, let's say, at 4:30 the Hague time. The hearing is adjourned.
All rise. All rise. Please be seated.
I will now issue a number of oral orders. First, I hereby issue an oral order on the submission of a public redacted version of filing F-116. In this regard, I recall that in my decision on the defense preliminary motions F-147, I ordered the defense for Mr. Haradinaj to submit a public redacted version of F-116 by 15 March 2021. The defense for Mr. Haradinaj has so far not complied with the order. In this regard, I emphasize that regardless of whether the name of Specialist Chamber or SPO staff member is mentioned in a public transcript pursuant to Article 33 of the Practice Direction on Files and Filings, parties shall make reference to Specialist Chambers and SPO staff members only by their functional titles, unless strictly necessary for the proceedings, and preferably in submissions with a classification of confidential or strictly confidential, and reference to other personal information shall only be made upon approval by a panel or the President. For this reason, I hereby order the defense for Mr. Haradinaj to file by Thursday, 1st April 2021, a public redacted version of F-116, redacting the name of the SPO staff member in paragraph 70. This concludes my first oral order. Second, I hereby issue an oral order on the submission of a public redacted version of filing F-134. I hereby order the defense for Mr. Gucati to file by Thursday, 1st April 2021, a public redacted version of F-134, redacting footnote 4 of that filing. This concludes my second oral order. Third, I hereby issue an oral order regarding the reclassification of two filings. I hereby order the registry to reclassify as public the following confidential filings: F-125, dated 15 February 2021, and F-126, dated 15 February 2021. This concludes my third oral order. Fourth, I hereby issue an oral order regarding the SPO's request for authorization of non-standard redactions, and this is filing F-155. In this regard, I note the following: that subsequent to my decision on certain witness contacts, filing F-136, the SPO identified additional records of a similar nature and disclosed such record to the defense on 4 and 17 March 2021, applying redactions equivalent to those authorized in my aforementioned decision. That the defense did not respond to the SPO's request for authorization of the redactions so applied, and that having reviewed the applied redaction, I find them to be in conformity with the conditions set out in paragraph 2930 of my aforementioned decision. For this reason, I hereby grant the SPO request and authorize the non-standard redactions applied set out in Annex 1 to filing F-155. This concludes my fourth and last order today. This concludes today's public hearing. I thank the parties for their attendance, and I also wish, as usual, to thank the interpreters, stenographer, audiovisual technicians, and security personnel for their assistance. The hearing is adjourned.
All rise.